My name is Jay Chauhan. I'm a lawyer in three jurisdictions in England, Canada, in Ontario, and India. And today I want to talk about preparing a modern will. So, how do you prepare a will? Most of my practice has been in Canada, in Ontario, in a town called Richmond Hill. And today I want to talk about the way a will is prepared in a modern context. And to just explain, we did something today which may give you an illustration of how we use technology and also the issues of preparing a will in the modern times. In a country like Canada, where a lot of people who are immigrated have properties abroad and have their children who are mobile and live in different places. So I will just summarize the key issues that we just went through from my experience. So first of all, the use of technology. I think just to give an idea, there was a lawyer in our office who interviewed the client alone to assess the mental capacity. And in the Ontario law, it probably is true of other jurisdictions as well, that the will that you prepare must be done, and at the time of signing, the person that is signing the will should have the mental capacity to prepare a will. And that assessment was done by one person. I watched the interview from another location on Google Hangout, and the person lives in a town called Thornhill, which is just about 5 miles south from Richmond Hill, where we are. And the client had come, and then the assessment was done. I felt, and the other lawyer working with me felt that there was mental capacity. So then we went into details to assess the property, the interest in the house, whether it was jointly owned or owned as tenants in common. So in Ontario law, which follows English law, it's very important to recognize that the house is very often in joint names between husband and wife with the right to survivorship. So if the one person dies, the second person inherits the house, and the property does not go through the will, but simply is taken over as a survivor on the register. So that assessment was done. Another thing to keep in mind for those who are lawyers in our group listening to the video is undue influence. So just to make sure that the undue influence does not create a problem, that we kept the family members sitting in the outside and not in the meeting to make sure that the elderly person who is writing the will is alone giving instructions and who knows and understands what his relatives are and how many children, how many grandchildren, and then how he makes his disposition. So that's how the decisions were made. And the second thing that will happen then, based on those instructions, we'll prepare a will, send it to the two children with the consent of the testator, as I call it, the person preparing the will, so that I personally feel that after your role as a lawyer is to advise the testator actually. But when you do so, it is once you get the permission from the person who is signing the will, that the other people of the members of the family are aware of what is being said in the will, and they consent to that arrangement. The risk of conflict later with the beneficiaries going to court and saying that something was wrong in the will is diminished in my view. So I take the precaution of getting the consent, and then getting the wills seen and approved by the children. And that is not the duty of the lawyer to deal with it, but you can get the consent, and that your performance of duty as a professional to the client is then performed with other extra care to make sure that the beneficiaries do not challenge the will. If they do, then you will end up as a lawyer in the courtroom trying to give evidence of what the intention was. So that should be avoided. So it's very important that those people who are lawyers in the group and those who are even clients in our group, Angel Mentorship Group, they are aware of what precautions you should take to avoid negligence. There is an English case which is followed also in Canada that indicates that the duty of the lawyer is also to the beneficiaries. So if there is an obvious error on the face of the record that you didn't look after the interest of the beneficiaries properly based on the instructions given, then the lawyer could be liable. So I think there is another provision that you have to worry about, both if you're a client or if you are a lawyer is the provision with respect to the dependent. There was a separate statute in Ontario called Dependent Relief Act, which is now a part of the main the law and no longer a separate statute, but the obligations of the lawyer to address that issue are still there, which is a part of the current law, which is that if you find as a lawyer that the client who is signing the will has a dependent, fully depending on the person making the will, then you have to make sure that the provision is made for the benefit of that particular dependent. Otherwise, the dependent has a right to set aside the entire will and ask the court to set aside funds to support the dependent. So any dependent provisions should be addressed in the will as well. So this was my experience. I'm going to do frequent videos for the mentorship group. Join my group at Angel Mentorship Group on the Facebook. Feel free to make comments. I'll be doing a number of videos as frequently as possible, and in issues that are important, which are designed for the lawyers, I'll be doing CPD programs. CPD stands for Continuing Professional Development, and Ontario lawyers are required to do 12 hours of educational lectures every year and record it to maintain their license. So I'll be doing those lectures for the lawyers. And there's also paralegals in Ontario that we support. They cannot prepare the wills, so this video was more designed for those interested as clients and also lawyers who are students or lawyers themselves who want to improve their ability to work in this area. I will be doing another video to explain that when you do the will, you can create mechanical systems of names and forms which can be filled in very quickly. And if you really do this properly, how can you do it so that you have two wills, husband and wife, your account, and the affidavit of execution all done in one go. So hope you enjoyed that video, and look forward to seeing you again. Thank you.